Thank you for joining in now for our Money Smart Meetup with Chen. We are on the topic of estate planning toolbox tonight. And I'm going to kind of talk slowly here while people join in. We have a big group attending tonight. And I know that I got a few emails about, could you resend me the link? So I ended up sending out the link to everybody. So sorry if you got too many extra emails, but hopefully everybody who wanted to join tonight will be able to join in. And this is our regular Money Smart Meetup program. We've been doing this at the library for about 6 years. I really need to look up that. It's been about 6 years now. We do it about once a month. We do it once a month. Occasionally, like during the summer, we might skip a month or something. But we've been doing it for 6 years. We do different topics every month, and on all different topics of money matters. So from credit, building credit, to paying off debt, to first-time home buyers, and all kinds of subjects. So we have been lucky enough to have Chen with us. She was actually with us in October for a program, and then we've had her for this 4-month series, January through tonight is our last one, sadly, with Karen, but we will hope to have her back again later this year. So tonight's topic is estate planning toolbox. The previous programs that we had with Karen were in the month of January, it was 12 months to take charge of your finances. February's was about, oh my gosh, I was going to write these down.
Taxes.
Credit.
Oh yeah,
credit history, and identity theft protection.
Right.
And then March, we did 10 steps to a smarter tax return. And then that seems like it was just like last week, but here we are again in April, and we have this topic. All of those previous programs are available on our library website. If you didn't get a chance to see them, you can go to our library website, which is egbpl.org, and you can look on the on-demand section, which takes you to our YouTube page, and you'll find all of those programs there for a while. They won't be there forever, but they'll be there for a while longer. And then tonight's program, again, will be up on there as well. If you have to give me till next week to get it up, or like early next week, it'll be available if you wanted to watch this again. But Chen's been great. We are so happy to have you with us again tonight. And Karen's a certified financial planner, but as she'll explain, she is an educator, a financial educator, and doesn't practice as a certified financial planner. So, but I'll let you can explain that better. And the program tonight, she will give her presentation, and we'll do the questions at the end. So please feel free to type in your questions as you think of them. You can use the chat feature, or you can use the Q&A. Either way, I'll be monitoring that the whole time. And when Karen's done with the presentation, I will then make sure she gets all the questions answered, or I'll pass them to her for her to answer them. And that's the way we'll go. So I'll turn it over to Karen now, I think. And I'm gonna turn off my camera, but I will be right here and monitoring all questions. So, okay, take it away, Karen.
Thanks, Nancy. Let me get started to share my screen here. All right. Okay, you should be seeing my first slide, and give me one more moment while I get my presenter screen up here. Okay, so yes, talking about estate planning toolbox tonight. I think as we go along, I think you'll agree with me that I really am doing this from from the perspective of an educator. I'm not going to be talking like an attorney tonight. I am not an attorney, and so certainly tonight is not legal advice, but trying to get you familiar with the tools that we do use in estate planning, maybe to help you understand things you've already done, maybe to help you be better prepared to ask good questions and understand what is going on when you do work with an attorney for wills or trusts and so forth. But as Nancy said, financial education is what I have spent my professional life doing. As she said, I don't take clients, but I got the certified financial planner designation so that I could do a better job with subjects like tonight, where oftentimes somebody wouldn't really get much education about estate planning without paying for an attorney's time to get tasks done. Now, estate planning actually can be quite complex. So tonight is not going to give you every detail that you may need to know, but I think the goal is for you to become more comfortable and more familiar with the tools, and the terminology to a certain extent is a challenge as well. So tonight is education. It's not advice. And so I'll be telling you about each of these tools, but I won't be telling you exactly how they might work in your situation or whether they should be used in your situation. So it won't be surprising if you decide that you do need qualified professional advice based on your situation. At the end, and it should be also at the end of your handout, I think, the link to my webpage, where I've posted one thing in particular that people always ask about during this program, and that is how to choose, how to find an attorney who does particularly estate planning work. And so on my website, which is KarenChanFinancialEd.com, there's a tab called Resources. And on that tab, if you'll choose tonight's program title, Estate Planning Toolbox, the first things that you'll see on there, one is a guide to how to choose an estate planning attorney, and the other two are places where you can search for attorneys who focus on estate planning. So I hope that'll be helpful to you. Now, a lot of people, when they hear the word estate, their first reaction is, well, I don't have a lot of money. I don't really have an estate. Well, to be honest, almost everybody does. If you have a bank account, if you own a house, if you own a vehicle, if you have some savings, if somebody owes you money even. And I've thought about whether I should put a child on this slide as well. A child is not a financial asset, they're more of a financial liability. But nonetheless, if you have a child, you need to do estate planning because their future is what will be at stake if something should happen to you. And a lot of us think we haven't done any estate planning, but odds are you've done some and you may not have even realized it. Maybe you have an IRA or an employer retirement account, and you chose beneficiaries for that account. That is estate planning. When you buy a car, especially if it's a married couple, you make a decision whether a car is owned in the name of one individual or whether it's owned in the name of both. That's actually estate planning. If you've had a will drawn up and many of the other things that we're going to talk about, this is all part of your estate plan. And one of the things that I think you'll take away tonight is that all of these pieces need to make a coordinated whole. I'm going to show you some examples of estate planning gone awry, and it will typically be because there wasn't coordination among the different pieces of the estate plan. So what does estate planning do? We typically, I think we all focus on the piece of it. It's a way of saying who we want to get our stuff and how they should get it when we pass away. But there are many other things that estate planning can do. One that it can help you do, which is actually very valuable, is providing tools for your finances and other affairs to be managed if you become unable to do so. When you do pass away, there will be taxes in some cases, there will be costs to the transfer of property, and estate planning to a certain extent is a tool for minimizing not just taxes and costs, but time as well. looking after family that would be left behind is a goal that many people have with estate planning, making sure that there are arrangements for who would look after the minor children, what money will be available to help with the people that we leave behind. And other perhaps less important ones, some people are concerned that when they die, and if everything goes through probate, through a will, it all becomes a matter of public record. Now, genealogists love that down the road, but the deceased may not want it that way. Privacy is something that may be a goal of your estate planning. Avoiding court proceedings is probably not the top thing that was on your mind tonight, but proper estate planning can do that. Now, sometimes just by avoiding, arguments among people, but the other way that we avoid court proceedings, and this is one that's kind of personal to me, we did avoid this, but when you have an older adult who becomes incompetent, unless they have something put in place for someone to manage their affairs, those who are concerned about them end up going to court to have the court label the individual as incompetent and appointing a guardian for them. That's not a very pretty thing to go through, and it is very public. Estate planning can also help some with protection of assets. And another thing that it can do is to make things easy for heirs. My dad's joke was always that he was just going to walk out of the house and close the door, and he and my sister could deal with it. Well, actually, he used to say, when I'm gone, you and your sister can fight over it. And I finally said to him one day, and this was long after he had dementia, but he'd always said this. And I finally said one day, Daddy, do you think we're really going to fight? No. Well, then will you stop saying it? And he did. But what he did do was literally walk out of the house and close the door when he moved into assisted living. And my sister and I, had to deal with everything that was left behind. It wasn't actually a bad thing. Maybe it was better than having him try to make decisions. But at any rate, these are the kinds of things that estate planning can help with. And why does it matter? I don't usually teach by giving negative examples, but that's what I'm doing tonight because they make the point so well. So here's the first negative example. We have Ella. Ella has a will, and it says that her daughter is supposed to get all of the actual money, and her son is supposed to get the house. Now, the main money that Ella has is in an IRA. On the IRA, she has named both children as beneficiaries. There's a conflict here. What will end up happening is the beneficiary designation on the IRA rules. So the daughter will get half, the son will get half. Then the will takes over with what's left, and what's left is the house, and the will says the son gets it. So the son gets it. And so Ella probably unintentionally left more to her son and less to her daughter than she really desired. Second negative situation. We have a second marriage for Maya and Tony. Both of them have children from her previous marriage. They really haven't done any formal estate planning. They don't have a will. They don't have a trust, but they own pretty much everything jointly. And so they think there's not too much to worry about here. Maya passes away. Because the property is owned jointly with right of survivorship, everything goes to the survivor, which is Tony. Unless Tony has a will written or sets up a trust, upon his death, most any state will have state laws that would say Tony's children will get whatever he left behind. Because they didn't plan, Maya and Tony have disinherited Maya's children from the previous marriage, and Tony's children from his previous marriage will end up with everything. Third example, Winnie is a widow. She has one child named Don. Clearly, she wants him to have everything. They're on good terms. And so she simply adds his name to all of her assets, to the bank account, to the house, and whatever else. But what Winnie doesn't anticipate is that Don and his wife get divorced. And like any court proceeding, discovery is part of the process. And in a divorce case, part of the discovery is declaring all of the assets that you have? Well, what's on Don's list of assets? Half of his mom's house, half of his mom's bank accounts, half of anything else that she put his name on. And although it's kind of unlikely, Winnie could end up jointly owning her home with her ex-daughter-in-law. Not at all what Winnie was thinking about when she put Don's name on things. And then we have Tom and Tina, who did their job in 1997. They had wills drawn up. And the plan that was underlying what was in the wills was that when the first one should pass away, virtually everything would go to the surviving spouse. Well, Tom died in 2018, 20 years later. And because of changes in the law and because of the exact way that the will was written, what happened because of the change in the law was that Tina got almost nothing and everything went to the children. The law in this case that changed was the law about how much you can leave to people other than your spouse without your estate owing estate tax. And the wills were written in 1997 saying, give to the kid, only give to Tina what is left after you give everything to the kids that can be given to them without owing estate tax. Well, at that time, that figure was about $600,000. When he died in 2018, the number was right at 11 million. And so that's what, but the phrasing, the will didn't have an exact number. It just said, give everything to the children that can be given to them without incurring estate tax. And so the outcome was not what they had intended. But we don't have to suffer outcomes like that. If we understand what's in our toolbox and a little bit about how they work together, we can avoid some of these fairly obvious mistakes. And in the course of Tom and Tina, of course, they did estate planning, right? They had the will drawn up, but they thought it was one and done, put it in a drawer and forget about it. But you have to review your estate planning from time to time because you have family changes, divorces, new grandchildren, what have you. You have financial changes, perhaps, where you didn't have very much money back when. Now you've had a couple of fairly well-off relatives pass away. You've done a good job saving yourself. Your financial situation may have changed dramatically. That impacts the planning that you need to do. And the law changes is another thing. So even though you've done your estate plan, you can't just forget about it. You have to review and sometimes update. The tools that we're going to talk about tonight are titling of property, powers of attorney, trusts and wills, lifetime gifts, which you probably weren't anticipating we'd discuss, and then we'll talk about taxes. To be honest, mainly income taxes, but we'll also talk about estate taxes, even though under today's rules, most of us are not impacted by those. So what does titling of property have to do with estate planning? Well, depending on how property is owned, it either says nothing about who gets the property or it determines entirely who gets the property upon death. With sole ownership, for example, during the owner's lifetime, they can sell it, give it away, use it as collateral, against another loan. They can do whatever they want. And upon their death, they get to say who gets it. In contrast, if you own something as joint tenants with right of survivorship, that with right of survivorship are the four key words here. It means that in this case, we have more than one person owning a piece of property. And because it is owned like this, when one passes away, the survivor or survivors will automatically own the entire thing. There's no ifs, ands, or buts about it. I still remember when I first encountered this phrase. I was a newlywed. My husband and I had opened our first joint bank account, and we got a statement in the mail. And it listed our names, and afterward it said JTWROS. Well, I was clueless, but I am curious. So I called the bank and I said, what does this mean? And that was my first lesson in what does joint tenancy with right of survivorship means. Now, there are two other ways to own property jointly. One is tenancy in common. And Whereas joint tenants with right of survivorship sort of views each of the owners as owning the whole thing at the same time, tenancy in common really views you as owning separate parts. And under tenancy in common, you each have total control of your parts. You can sell your part, you can gift it, you can leave it to somebody at your death without the other owner or owners having any say-so in the matter. So it operates totally differently from joint tenants with right of survivorship. Tenancy by the entirety, you will encounter less often for two reasons. One, because it can only be used by married couples. And secondly, in Illinois, it can only be used for titling of real estate, not other types of assets. But this is actually a variation on joint tenants with the right of survivorship, even though you wouldn't gather it from the name. What it does that's different is if there is a creditor for one of the couple, let's say you're it's a woman married to a woman who actually runs her own contracting business, and the husband does something else that's less risk, and the wife gets sued somehow regarding a problem with something that she built. If she's the sole owner of that business and the lawsuit is only against her, that creditor cannot file a claim against property that is owned jointly as tenancy by the entirety. The only creditors that could get a judgment against that asset would be creditors that had a debt to which both of the married couple were subject. For example, if there was something that happened to the house that they jointly owned together, and let's say there was an accident, an injury that caused huge amounts of expense and cost, and they were suing for recovery of those costs, they could potentially look at the house because it's owned jointly by the same two people who are being sued. There's no extra protection there, but there is protection if there's a lawsuit, if there's a creditor who is trying to get compensation from one of the owners. In that case, property owned as tenancy by the entirety could not be taken to satisfy that judgment or that lawsuit. One other thing that comes under titling of property is not just who owns the asset currently, but who will own it upon the owner's death. And these are three very similar but differently named tools. We have beneficiary designations that apply to pensions, IRAs, and other retirement plans. We have transfer on death, which is often abbreviated as TOD. You use this on securities. That means investments, mainly like mutual funds or stocks. Also, you can use it on real estate in Illinois, and as of just a few years ago, on automobiles in Illinois. Payable on death, again, works the same way as beneficiaries and transfer on death, but payable on death is pretty much specifically for bank accounts. How are these similar? It's a way of stating who will own this account upon the death of the original owner. And for this beneficiary or the person that's listed in the POD designation or the TOD designation, all that individual has to do is show a copy of the death certificate, prove who they are, fill out a form, and they take ownership of the asset. Little delay, no cost. But this is preferable pretty much to what and I've forgotten who was my example that left everything to her son Don. The alternative that she had, rather than putting Don's name on everything, was to, on the house, use a transfer on death designation. On the bank account, use a payable on death designation. On the IRA or what have you, use the beneficiary designation. What's the advantage? While she was alive, Dawn had no legal claim on any of these, and she could have changed her mind. These are all fluid until the owner actually passes away. So these are ways of achieving the goal of passing something on to a particular individual upon death with very little muss or fuss, without taking on any complexities during your lifetime because of taking on joint ownership instead. Okay, so leaving ownership issues and looking at the next tool, which is power of attorney. A power of attorney is a legal document that designates, where you designate who you give the authority to make decisions in your place during your lifetime. There are two types of powers of attorney. One is for property. You may also hear it called a financial power of attorney, and the other is for healthcare decisions. They're two separate documents, and we're going to be focusing tonight on the power of attorney for property, but the concepts are very similar here. So in a power of attorney, there are two roles that are going to be used. One is the person who is giving authority, and the other is the person who receives the authority. So the person who is giving their authority to someone else is called the principal. The person who receives it, who will be able to act in their place, is known either as an agent or an attorney in fact. There are also, though, different ways in which the power of attorney can be written that determine when it takes effect, when it ends, and how much the agent or the attorney in fact can do. So under types here, I've listed limited versus general. A general power of attorney means that your agent can do pretty much anything that you can do, from not just paying bills, but perhaps selling investments, making financial gifts to individuals. That would be under a general power of attorney that really doesn't restrict what your agent can do with your finances. A limited power of attorney could be something that relates mainly to, like, I don't know, maybe it's mainly for trading stock. I can't imagine why, but perhaps. But it could be more limited in a different sense. When my husband and I were selling our first house, we were actually moving back here to Illinois. He had already come. I was still out in the other state trying to get the house sold. And it was going to be quite an expense for a young couple like us that didn't really have much in the way of liquid dollars. It was going to be quite an expense for him to have to buy a plane ticket on the spur of the moment, come back, sign the sale documents, and then, come back to Illinois. And so with the wisdom of our real estate agent, we had a limited power of attorney drawn up where my husband gave me one authority and one authority only, and that was to sell documents related to the sale of this particular house. And once the house was sold, the authority ended. So limited versus general. And then as far as when the power of attorney is in effect, a power of attorney can be springing. It's either springing or it simply isn't springing. Springing means that and this is the way I envisioned, it springs into effect upon some event. A typical one that would be used is when an individual has been determined to be incompetent, that then the power of attorney would spring into effect. Up until that point, the agent wouldn't be able to do anything. There are times when you don't want a springing power of attorney, but they can be useful in certain situations. Now, what about durable? This doesn't have to do with when it starts. This has to do with when it ends. A durable power of attorney is one that endures the principal's incapacity, meaning that when the principal does develop Alzheimer's or is in a coma, the power of attorney still is a legal document that can be enforced, and the agent can act using that authority. If it were not durable, the authority would end when the principal became unable to make decisions for themselves. So in most cases, we want a durable power of attorney. We may or may not want a springing power of attorney. To do a power of attorney, there are two ways to go about it. One is the do-it-yourself approach using statutory forms, meaning that the state has created these forms. They're templates with checkboxes and fill in the blanks that any individual can download and fill out themselves and get it witnessed, and it'll become a legal document. These forms were revised in 2011. If you have powers of attorney that were drafted before that time, they're still legal. But the changes in the 2011 revisions, at least for the power of attorney for property, were intended to make it less of a problem trying to get financial institutions to honor the power of attorney. And I appreciate what they did, because with my dad, on his power of attorney, my sister and I were named as joint agents, not successor to one to the other, but joint agents. And we had financial institutions who would not deal with us because they didn't accept that type of power of attorney. Well, Illinois' statutory form no longer allows joint agents, and that's why. It's one of several things they did to make it easier for institutions to honor these, so that the agent is less likely to run into problems trying to do what they are intended to do on behalf of the principal. Now, the statutory forms are one way to do your power of attorney. The other is to have an attorney draft it. And if you're already working with an attorney, to have a will drawn up or to have a trust set up. Having them also draft your power of attorney will likely add very little cost, and then you'll know that if there is anything specific to your situation that should be reflected in the way the power of attorney is drawn up, you'll have somebody who already knows your situation to be able to draft it accordingly. Now, when does the power cease? I already mentioned that if a power of attorney is not durable, that then it ceases when the principal loses their mental capacity. But in general, there are two ways that a power ceases. The most common one is with the death of the participant. The power of attorney does not survive the principal's death, with one exception. And that is a healthcare power of attorney. And that agent could make the final decisions about the disposition of the body, including whether or not organs would be donated and such as that. But the other way that you can say in a power of attorney that the power will cease is at a triggering event. In the example I gave about the sale of our house, the triggering event that ended the power was when the house at this address had been sold. If you were taking a trip around the world and you had a power of attorney so that somebody could take care of things while you were gone, the springing triggering event might have been when you boarded the cruise ship, and the triggering event for the power to cease might be when you stepped on U.S. continental soil at the end of that trip. So two different ways for a power to end. Now, I'm going from powers of attorney to trust because the two actually have some similarities. The similarity is that they can both provide a way for someone to manage your affairs while you're still alive, but unable to manage them yourself. But a trust can do much more than that. A trust is a legal entity. And it is a legal entity that occurs at a particular point in time, and it may or may not allow changes to be made. So therefore, we have these two different ways of categorizing trusts. First, on the left-hand side, a trust could be revocable, or you'll hear it pronounced revocable. It means that the trust can be changed. The person who set up the trust could change their mind. They could end the trust. They could take assets out of the trust and put different assets in the trust. It is still very fluid. The grantor of the trust still has a lot of control, or still has control over what happens with that trust. But when a trust is irrevocable, it means that it's set up and pretty much cast in stone then. The terms of the trust probably cannot be changed. What assets are put in the trust may not be able to be changed. Most of us do not have irrevocable trusts. They are typically used mainly for planning about estate tax, putting things into a trust at a point when they're worth less, hoping that they will increase in value, but that greater value will then be outside of the estate by the time the individual passes away. Now, on the right-hand side, when does the trust have legal standing? Most of us have lifetime trusts, revocable lifetime trusts, or you may hear it called an inter vivos trust or a living trust. It means that the trust exists during your lifetime. It can continue after death as well. And at death, it would actually become an irrevocable trust. But there are also trusts that are testamentary trusts, meaning that they come into existence upon the individual's death. Someone with a minor child might have a will that says, upon my death, my assets are to be placed in trust for the benefit of my child or my children. The trust didn't exist before the individual passed away. That is a testamentary trust because there'd been a determination made that it wasn't needed during the lifetime, but it would take effect and be set up upon the individual's death. So what are the things that a trust can do? It's pretty varied, actually. One of the appeals of a trust is that it avoids probate. It avoids that public process of your assets being distributed, which also means that a trust can avoid some of the costs of managing the estate, the delays that can happen before heirs actually receive stuff. Like I said, privacy will be an issue here. The trust process is private. Probate process is not. And one of the sort of added bonuses here is if you own real estate in more than one state, without a trust, you would have to go through probate in each state where you own, or your estate would have to go through probate in each state where you owned real estate. But if you put all of that property into a trust, you've avoided probate in each of those states. So that's a little bit more of an incentive, I think, to do that. But trusts also provide a vehicle for managing assets both during your lifetime and afterward, and distributing the assets typically after your death. And so this also is a vehicle that works not just for typical distributions, but also where particular kinds of management and distribution is needed when you're dealing with minors who need to have money made available and handled by the trustee, for their benefit, or if you have a disabled individual who may be receiving support from certain state or federal programs, and the trust needs to be set up so that only certain amount of money and only certain types of assistance is provided. Another situation that trusts can help with is when for some reason you either want to separate assets and the benefits that come from them, or simply to keep one pot of assets separate from another. Let's say you have a late in life marriage of a wealthy individual to a younger person who has very little property. And maybe the older, wealthier individual wants to keep their property separate. They don't want it to become marital property so that this younger new spouse with whom they have not perhaps yet had children even, so that they don't it doesn't automatically fall to them upon their death. And so they can set up a trust that says, my spouse can get benefits. They can get the income and so forth from all of these assets in the trust, but they don't have control of the assets. And upon the death of that younger spouse, then the assets actually pass to the children of the older, wealthier individual, that set this whole thing up to start with. Trusts can allow you to exert some control, even from beyond the grave. You can dictate after your death, how assets are going to be managed, how they're going to be distributed, maybe over the course of years, maybe over the course of generations. A trust is also can also be a tool for protecting assets, either protecting them from, maybe you have a child or grandchild who tends to go through money pretty fast. Trust can help protect them from themselves. It can also help protect the assets from creditors of that heir. And in the case of that irrevocable trust for wealthier individuals who put assets into those earlier in life when the assets are worth less, they actually gift them to the trust, pay any estate tax that's owed, and then later on when they pass away, the deceased no longer owned them at the point of death. They were owned by this separate trust. And so that's a vehicle that can help manage estate taxes. Now, the terminology of trust can be a little confusing, so I want to get you comfortable with that. So who are the parties to a trust? The one who sets it up is known either as the grantor, the settlor, or the trustor. This is the person typically who's going to fund the trust, meaning it's their assets that they're putting into this thing. The trustee is the person who manages the assets in the trust. Typically, you not only have the primary trustee, the original trustee, but you'll also name a successor trustee or trustees so that when you, perhaps, you're also the grantor, you may be also the original trustee, so that when you either pass away or you become unable to manage this, you've already named who will take over as trustee after you. And the third party to the trust is the beneficiaries, the people who actually get either the income or other benefits from the estate, or who eventually actually receive the assets themselves. And those assets, that's the what. That is known as either the corpus or the principal. And please remember this. Without the corpus, without that principal inside of it, the trust doesn't really exist. There's a paper document, but it doesn't own anything. And without it owning something, without it having control of something, the trust is actually worthless. And this is a mistake that I have heard over and over again over the years from both attorneys and financial planners and tax people, that they will have a client who says, oh yeah, I've got a trust, that's all taken care of. And then when push comes to shove, they discover that no, the individual never retitled their assets into the name of the trust. They had a document, but they didn't really have a trust. They never funded it. So when you have a trust drawn up, the next step is to create the what inside the trust. Retitling the home, retitling the financial accounts, retitling the car even into the name of the trust. This is not, I think, in your handout anywhere. The one thing that you should not try to retitle in the name of the trust is any type of retirement account. A retirement account has to remain in the name of an individual, not even joint. It has to be an individual. If you try to retitle your 401k or your IRA into the name of the trust, you will have just caused a 100% taxable distribution, because that simply can't happen. But pretty much anything else could be retitled in the name of the trust. And how do you get a trust? Well, typically by working with an attorney. You've seen how varied the purposes of the trust can be. The situation that causes someone to decide or to be told that they should have a trust can be very different. And so there really isn't a boilerplate document here that will work, contrary to the statutory forms for the power of attorney, where an individual can pretty well set up their own power of attorney. Not so much with a trust. And so this is where you'll have to invest some dollars to get this task done for you. And typically, on the cost for a trust, we're talking in the thousands of dollars. It's been a few years since I have kind of asked around trying to get a sense of what current fees would be. But I guess I'd be surprised, especially in this part of the country, if you could get a trust done for, my guess is you're probably talking about $3,000 and up, and it could be up substantially depending on the complexity of your situation. So here, what I've tried to do, and you have this chart in your handout as well, kind of contrasting trusts and powers of attorney, because there is overlap, that they both are a vehicle for designating someone who can control, who can manage your assets while you're living if you are unable to do so. But other things are quite different, like the cost. Whether it has anything to do with probate, assets inside of a trust do not go through probate. Assets that your agent under the power of attorney has been managing will go through probate, because the power of attorney ends at the death of the principal. And so the power, you can think of it this way: power of attorney is before death, will is after death, so they butt up against each other, but the trust, extends over that time period. We talked about retitling of property into the name of the trust. And I think we've talked about these other items as well, but that will help you to kind of refresh your memory. How do these compare? What are the advantages and disadvantages? So now let's talk about wills. And you may have expected that this was going to be the first thing that we talked about, because usually I think for most of us, when we think about estate planning, a will is the first thing that comes to mind. And yet it's actually not the most powerful of some of the tools that we have. Well, maybe that's not the right way to say it, but it typically doesn't control as much of what we leave behind as we expect, because it only controls the things that are not distributed by some other mechanism. If we've already said, if something is in a trust, it doesn't go through probate, that means the will has no control over it. We've already talked about how joint ownership with right of survivorship, that drives who owns the asset at the end. The will has no control, but wills are still important, because a will is your place to name an executor, the person who will oversee your estate in general, make sure that everything is done that needs to be done to wrap up your assets and other things. The will is the only opportunity you have to name a guardian for a minor child or for a disabled individual that you hold guardianship for. And it's the place where you will provide instructions about how your probate estate should be distributed. Now, just like with the other tools we've talked about, we have some terminology here. So what are the roles to a will? The testator is the person who is going to have their assets managed and distributed. The executor is the person who's going to do that. Now, if you hear someone using gender-specific language, if it's a female, they will say testatrix and executrix instead of testator and executor. Same responsibilities, it's just a gender-specific term. And then who are those people who get the stuff? Under a will, technically, they're known as a devisee, a legatee, or a recipient of a bequest. You'll notice that the term heir does not appear here. That's because technically, an heir is someone who inherits when there was no will, when the individual died intestate, meaning without a will. That's when you have heirs. So this is the point where I wish I could see your faces, because I'd like to read how you're responding to this. This is a joke. It's not meant to be serious. But based on what you just learned, if you want to kind of freak out your kids momentarily, or whoever you're going to be leaving things to, you can call them up later tonight or tomorrow and say, just wanted to let you know that you are not my heir. And depending on the relationship with that person, there will probably be either dead silence or somebody will be screaming. Hopefully it'll be the dead silence, which will allow you to step in after a moment and say, that's because I have done my job. I have a will, or I have what other vehicles in place, and therefore you won't be an heir, because an heir means that I didn't do my planning, and you would inherit by the laws of the state instead of through my will. I've done my job. So now you're a devisee, legatee, or recipient of a bequest. Take your pick. Okay, and then the final role that has to do with wills is that guardian, where you're naming or nominating who to take charge of the rearing of the children. So as I mentioned, the will controls only part of your estate. And what it controls is known as the probate estate, which is made up of only those assets that weren't distributed by one of those other means, the trust, the joint ownership, contract, beneficiary designation. If those things were in place, the property's already been distributed by the time the will has anything to do with it. And what is probate? Another word that we throw around. It's a legal process, usually a court supervised process, where the first step is, if there is a will, to validate the will and say, yes, this is a legal document under this state's law, or to determine that there was no will and the person died intestate, that word that I used previously. And once that's done and the executor has been approved, and typically gets a letter saying that they are approved, then that executor will proceed to identify all of your assets, inventory them, have valuations done for items that don't have clear dollar values, and then handle the distribution. That is what the probate process is. So kind of graphically here, again, what is in the probate estate? What does the will actually control? Well, you start out, you've got everything that you leave when you pass away, but you're going to take away from that anything that passed by beneficiary designation or payable on death or transfer on death. Those are already taken care of. Anything that was owned as joint tenants with right of survivorship or that variation known as tenancy by the entirety. And we will take away everything that's already in a trust because the will doesn't control that. And so what's left then is the probate estate. And that is what the will controls and what the executor will be dealing with. How much the will actually controls will vary a lot depending on the situation. So here's an example. We've got George and Gladys, and they each have a will. They're a married couple. They pretty much own everything as joint tenants with right of survivorship. And the only things they don't are those retirement accounts that I mentioned that they have to remain in the name of the individual. But what they've done is they have each named each other as the sole beneficiary of the other spouse's retirement accounts. So years pass, and eventually George is the first to die. Because everything was owned jointly, except for the retirement accounts, and Gladys was the sole beneficiary on each of those, everything pretty much automatically went to Gladys. There really wasn't much, if any, probate estate for George's will to deal with. Well, Gladys lives a while longer, and eventually she does pass. And when she does, we learn that she really hadn't done any estate planning since George's death. That means that she now owned everything as a sole ownership, as sole proprietor, if you will. And on the retirement accounts, she now owned them. She had not named any beneficiaries on them herself. And so when Gladys dies, her will controls everything. Total change. When George died, his will didn't have to do hardly anything. But when Gladys dies, her will and her executor and the probate process will handle basically everything that's in her estate. How do you make a will legal? It depends on the state. It's by state law. And the way that you make it legal, that process is known as executing the will. And in Illinois, that means that you have to sign the will in front of two witnesses, and that those witnesses will sign the will as well. Now, like I say, the rules vary by state. You, like me, may have seen some of those kind of B-grade made-for-TV movies from back in the 60s. I'm dating myself here, where you have some individual literally lying on their deathbed. They've got a piece of paper, they've got a pen in their hand, and they're desperately trying to get their will written. And in the more dramatic scenes, of course, they die just before they can sign their name. And in some states, that holographic, meaning self-written will, would be a legal document if they can verify it's the person's writing. And even better if it was signed, then yeah, some states will take that, but not in Illinois. So don't try to pull that dramatic thing off here. If you want to make changes to your will, you don't open it up in Word and do track changes. You have to do a codicil. It's basically an amendment that meets legal standards, and those legal standards are the same as the will had to meet. So in Illinois, a codicil would have to be signed in front of two witnesses, and the witnesses would have to sign it. What it does is, though, it avoids having to rewrite the entire document. You can, of course, have a new will written that revokes all previous wills, but a codicil is the alternative. Now, what does happen if you should pass away without having a will? We already learned the name for that. That's called dying intestate. Each state has its own laws. Illinois' laws of intestacy are 13 steps that the state would go through. I've kind of boiled them down here to 1, 2, 3, 4. But the first step is always looking to see, is there a spouse and are there children? If there's only a spouse, then under Illinois law, 100% goes to the spouse. If there are only children, then 100% to the children. If there is a spouse and children, 50% to the spouse and the other 50% divided among the children. And some people will hear that and say, well, that's pretty much what I would have done anyway, so why do I need a will? Well, let's say you have minor children. Minor children can't inherit directly. They don't have the legal rights. They can't make decisions about, they can't sign sales contracts and so forth. So a guardian would be appointed to manage the assets for your children. And what if the state, in all its wisdom, or the county, didn't choose your spouse as the guardian? You would have put your spouse in a position of having to go to this appointed guardian to get money every year to buy the back to school clothes for the kids. Not a very good situation. Okay, but back to the storyline here. What if there is no spouse and no children? Then they start to look out the family tree. What's the next level of relationship? Well, either grandchildren or grandparents. If they don't find any of those, then they keep going. They keep looking for relatives further and further out on the family tree. If they cannot find any, then the county takes control of the real estate and the state takes the other assets. But and the word for this is that the property escheats to the state or escheats to the county. And that word is spelled E-S-C-H-E-A-T-S, escheats. But it's not necessarily a permanent thing. You've seen those lists of property that the state has that belongs to somebody, and they publish the names and say, come claim your stuff. That's where the property would end up. It would be on that list for some forgotten relative, perhaps, to pipe up and say, actually, that's my great uncle's brother's, blah, blah, whatever, and file with the state and claim the property. So it's basically sort of held in trust until or in case that happens. In the case of a very small estate, and in Illinois, that means less than $100,000, the heir or heirs can file what's known as a small estate affidavit, testifying to the fact that the estate is worth less than $100,000. There is no real estate. They will be able to avoid probate. I used to think it was actually a streamlined probate process, but apparently technically it's avoiding probate. There's a form that you fill out and file with the county clerk. In essence, the heir, if it's more than one heir, they would simply be saying, we've agreed to how this is being distributed and it's done. Small estate affidavit. And again, in your handout, you've got this table to help you kind of compare and contrast what a trust does and what a will does, some of the differences between them, how they operate a little differently, kind of a summary tool for you there. Now, let's talk a minute about lifetime gifts, meaning, obviously, things that we give to people while we're still living rather than waiting until our death. There is actually a limit on how much we can pass to others during our lifetime without filing a gift tax return. The limit has been for several years and is still this year, $15,000 per person, both per giver and for the recipient. So for example, let's say my husband and I together wanted to give some financial gifts to some nieces and nephews. I could give $15,000 to each and every one of them, and my husband could give $15,000 to each and every one of them. And so together, we could actually pass $30,000 a year to each individual. No gift tax involved, no gift tax returns to be filed. Now, I have heard attorneys recommend that you never give anybody the whole $15,000. And that's because if these are people, okay, my husband and I have we followed a number of Chinese traditions, and one is cash gifts, small gifts, but cash gifts at Chinese New Year. And so if anybody ever really wanted to give us a problem, if we really did give, a total of $30,000 to one of these individuals in a year, somebody could come back and say, well, didn't you give them anything else? Well, yeah, we gave them, $20 for Chinese New Year. Well, you're over the $15,000 limit. You should be filling out this return, and it wouldn't amount to us having to pay gift tax, because what happens if you go over that annual limit, the second box here, yes, you're supposed to fill out a gift tax return. It's the gift version of the income tax return. But we have a choice. We could pay tax on the excess, over the 15,000, or we could say, that amount that we'll be able to leave tax-free when we die, just use some of that. And we'll be able to leave a little bit less without paying tax when we pass away. That lifetime exclusion amount for right now is $11.7 million. And so we could probably quite safely say, yeah, let's just use a little bit of that 11.7 million right now, not a problem. If we should happen to keel over in the next 3 years, any gifts that were over $15,000 would actually be brought back into the estate. So let's say that we were actually quite wealthy and we were giving hundreds of thousands of dollars to individuals and filing these gift tax returns. If we died within 3 years, those hundreds of thousands of dollars would be pulled back into the estate for the calculation of estate tax. So this is one of those places where the details get a little involved. Final point here about lifetime gifts. There's this concept of basis, income tax basis, meaning what under the IRS rules, what would the recipient be viewed as having paid for this item when they eventually sell it? And when I say paid, it's not actually what they paid. We're asking, what is the basis? Well, for somebody who buys something and later on sells it, like when you buy a home and later on sell it, your basis is what you paid for it plus the cost of improvements. For stock, it would be what you actually paid for it, period, plus any transaction costs. When you gift something to an individual, they take on the same basis as the original owner. So if I did have stock, I paid $10 a share and now it's worth $100 a share. I give it to that niece. She turns around and sells it. Her basis will be $10, just like mine was, because I gave it to her during my lifetime. And she will then owe tax on the whole $90 per share of profit. But that's quite different from what happens when someone inherits an asset at death. Inheriting, as you can see, is on the right-hand side of my diagram here. Inherited assets under current law receive what's known as a step up in basis, or it could be a step down if the value decreased. Step up in basis means, let's take that same share of stock that I paid $10 a share for. Now it's worth $100, but I leave it to my niece in my will. She then goes and sells it for the same $100. Her basis was stepped up to the value on the date of my death, which is $100. She happened to sell it for the same $100. She has no profit according to current IRS rules. Therefore, she has no income tax to pay. So this is one thing to consider when you're thinking about gifting assets, appreciated assets to someone else. Think about the tax basis that you're passing along and whether it might be better in an income tax situation to let them inherit it upon your death. If you gift assets that are not appreciating assets, I actually got this question Tuesday night when I did the same program. If you give somebody cash, cash is cash. It doesn't appreciate. It is a dollar. And with that, there's no appreciation. There will be no tax owed. There'll be no income tax owed when the recipient goes around and spends the dollars. We're talking here about something that increased in value from what you originally paid for it and how that basis gets transferred to the new owner. Now, I should point out, as far as this goes, that the Biden administration's income tax proposal, they have discussed doing away with the step up in basis at death. Haven't heard much about that since election, since inauguration. I don't usually prognosticate, but on this one, I will say that I think it's unlikely that this would make its way into legislation. And even if it did, I think it would be unlikely to make it through both houses. So I'm not too worried about the step up in basis going away, but you need to know that it is under discussion. The plan at least was for it to be included in his proposals for tax revisions. So, keep your ears open for that. And so to give you an example here again about what's the difference with gifting an asset versus leaving it to someone upon our death. Let's take this asset that I'll just say me again. I bought for $75,000. Now, eventually, I'm going to die. And when I do, it's going to be worth $200,000. And eventually, whoever gets it from me is going to sell it, and they're going to sell it for $225,000. Well, remember, we have two ways that I could give it to that person. One would be that I gift it during my lifetime. If I gift it during my lifetime, their basis is what I paid for it. So to calculate their profit, they would take the sales price, $225,000, and they would subtract their basis, the $75,000, and their taxable profit would be $150,000, or their taxable gain, I should say. What if I left it to them at my death? Well, they're still going to sell it for $225,000, but their basis was stepped up to the value on the date of my death, $200,000. What's the difference? $25,000. That's all that they're going to owe income tax on. Quite a big difference between owing income tax on $25,000 and $150,000. And at this point, I just wanted to point out, we've been focusing on income tax here because that's, for most of us, the bigger issue, since estate tax doesn't come into play until we get into the multi-millions of assets. But avoiding probate and avoiding estate taxes are two totally separate concepts. Avoiding probate has to do with how things are passed. Avoiding estate tax has to do with how much is counted in the estate as a whole. So let's review quickly here. What does go into figuring out what your taxable estate is? Well, once again, we're going to start out with everything. And I think the wording in the tax code is actually everything that the deceased owned or was entitled to. So you take everything that was supposed to be in the estate. Anything that's left to the spouse is not taxed as part of the estate. That's a non-taxable transfer. Anything that the deceased left to charity is also subtracted. That's not included in the taxable estate. And there are certain expenses that can be subtracted as well. So once you've taken mainly those three things out, what you're left with is the amount of estate that would be taxed. And how exactly does estate tax work? Well, as we mentioned earlier, each of us has an amount that we can leave without paying income tax. I'm sorry, without paying estate tax. And in 2021, that number is $11,700,000. These figures are about double of what they were before the Trump tax legislation. And the Trump tax legislation, most of the individual rules will revert in 2026 back to the previous rules. And this is one that will revert, barring additional legislation. And so that means that if you, for individuals who pass in 2026 or later, they will likely see their lifetime exclusion drop back to 5 million plus whatever the inflation adjustment would be compared to when we were last using this system in 2017. This exclusion amount does include any taxable lifetime gifts, because remember I said that was, if I was making large gifts, that would be my option to say, oh, just use some of that exclusion I was going to get to use when I pass away. If in a married couple, if the first spouse to pass does not use their entire exclusion, they can fill out a form 706 for the estate, and it will make the unused portion portable to the surviving spouse. Now, notice that in Illinois, it no longer tracks with the federal estate tax, and in Illinois now, estates over $4 million do pay state estate tax. There is no portability on an unused portion. The number is not indexed. It stays at 4 million. The rates you can see here are drastically different. The federal tax rates are 40% of whatever assets are taxable. The state ranges from 7.2 to 16%. And if you decide that you want to avoid one generation's worth of estate tax, and you're not going to leave stuff to your kids and pay estate tax and then have them pay estate tax again when it goes to the grandkids, you're just going to leave it straight to the grandkids. Well, the IRS already has your number. And so they impose something called a generation skipping tax, or GST, that leverages another layer of the exact same amount of tax as the estate tax itself, so that you don't really save anything by trying to skip a generation. So let's kind of summarize here. What are the takeaways that I would hope you would get from tonight? One is that whatever your goal is, there may be more than one way to get there. Some preferable to others, of course, but there's not just one way to skin a cat, as the old saying says. I still wonder where that came from. It's such a horrible thing. But let's say that one of your main concerns, and I'll be honest, I think this should be a concern of all of us. How will our affairs be managed if we become incapacitated? Individuals who live a long time have a very high probability of getting to this point somewhere along the way. So power of attorney is one way to make sure that you have a tool in place where someone else can step in and take care of things. A trust is the other main way to do that. And if you choose not to do either of those, that's when we're kind of back to that court proceeding where someone will petition the court to be named guardian in light of the incompetency of the individual. As far as transferring property to whomever you wish to leave things to, again, several options here. You can do it all through your will. You can do a lot of it through your trust. You can use lifetime gifts, you can use titling of property, or you can rely on those state laws of intestacy. I know that the phrase I was taught was, if you don't have a will, the state has one for you. That's what the state laws of intestacy are. So one way or another, assets will be distributed. I said at the beginning, estate planning is actually quite complex. We've given you, I think, the basics here, and I've tried to take something that can be a little bit of an intimidating topic and make something that you'll feel more, I try to make it more concrete, hopefully something that you feel a little bit more in control of. Maybe that means you decide to do things on your own to a certain degree, or like I said, maybe it means that you understand better what's already been done, perhaps by an attorney, or you'll be better able to understand conversations you have in future with an attorney and the things that they may recommend. I also mentioned earlier that I do have some resources with links on my webpage, and this is what I was talking about. So on KarenChanFinancialEd.com, under the resources tab, and then looking for the name of this program, Estate Planning Toolbox, that's where you'll find a few links, including links to the statutory forms for power of attorney and a few other things. But in particular, the first thing you'll find there is that guide to choosing an estate planning attorney, and links to a couple of sources for searching for attorneys whose main practice is in estate planning. So hopefully those will be helpful to you. So Nancy, I think we're ready for questions. So
Okay.
hoping you'll come back and
Yeah.
help us walk through those.
Okay. All right, we've got a few questions here. So Alan asks, can Karen explain the term living trust?
Yes. Living trust means the living part means that the trust is in existence while you're alive, meaning that you can and you should be retitling your assets in the name of that trust. It also means that it is a revocable trust, meaning that you can change your mind about things. The fact that you put an asset into it doesn't mean that the asset has to stay in the name of the trust. You could actually take it out. Most revocable living trusts or lifetime trusts, you, the person who set up the trust, are actually playing all three roles with the trust initially. You are the grantor, you're probably the initial trustee, and you're one of the beneficiaries. You're able to use the assets in the trust. What that means is that as long as that situation is maintained, when you file your taxes, you include all the trust assets as if the trust didn't exist, but that's just for that's just for income tax purposes. And so that's why some people, I think, are maybe confused about whether they actually need to title the assets in the name of the trust or not. I hope that answered the question thoroughly, but Ellen, if it didn't, come back and post again, and we'll follow up with that.
Okay. Okay, John asks, how are trusts and wills typically stored so that they are accessible upon death? For instance, both spouses die, how will these documents be accessed to be executed?
Okay. I'll be honest, I don't have a definitive answer for you on this. I have looked it up more than once, and I think it's kind of fuzzy. I have had some people tell me that it should be kept in the attorney's office. I have also read about it being stored, for example, in a safety deposit box that you have at the bank. But then I've also read about there perhaps being difficulties with the survivor accessing the safety deposit box in a timely fashion. That won't be quite as much of an issue for your will and your trust, but it will be an issue about your funeral instructions. So to be honest, I think I'm going to have to fall back on this and say, whoever the attorney was who drafted your will, ask them. And if you did it yourself, perchance, you notice I didn't really talk about that tonight because I don't know that that's a wise decision. But if you did do it yourself, then I think the best I can say is you put it somewhere that a trusted individual could get to it upon your death, and you make sure that they actually know where it is, or at least how to get to it. And that's the best I can do there, despite the fact that I have looked this up, not recently, but numerous times over the last 15 years, and never felt comfortable that I really had a definitive answer about it.
Okay. Alan asks again, can an institution like a law firm be named as the executor of a person's estate when a family member or trusted friend wouldn't work out best for that role or isn't available?
Yes, definitely. There are professional groups, that this is what they do, like you say, bank trust departments. There are private fiduciary services that I think do the same thing. And yes, this is often a concern because we may have family members that we trust implicitly, but who have no skills about this sort of thing. And so sometimes you want that professional skill set there, and you're willing to pay the fee to get that done. So yes, definitely.
Okay. John asks, can a trust include power of attorney provisions, or do you need a separate power of attorney document when setting up a trust? So can a trust include power of attorney provisions?
Okay.
Or is it two separate?
A trust is by default going to have the same kind of control over the assets that are in the trust that the power of attorney would give to an agent over assets that were not in the trust. So to a certain extent, by retitling assets in the name of the trust, you have already provided for the trust to be the mechanism with which to manage those assets. Things that you did not put into the trust would be managed by the agent under your power of attorney. Now, maybe one of the questions that's here, maybe the question is, okay, I do not think that you can give a trustee the authority to pull assets into the trust. That I'm pretty sure is beyond the scope of responsibilities that a trustee can have, unless it's the original grantor themselves. Can an agent under your power of attorney be given the power to transfer assets into the trust? I have to be honest, I have no clue. I've never heard that question asked. It would, if they could, it would clearly have to be one of the broadest powers of attorney. But what a trust could not do, your trust could never take on the responsibilities of the power of attorney for health, for medical decisions. Those would not be combined at all. And John, again, I feel like I hope I've answered the question. If not, come back and ping us again.
Okay. So yeah, feel free to type a follow-up question or anything else you want clarified better. Okay, Dale asks, with ownership of out-of-state property, does that require a separate trust?
I don't think so, but that's going to be a question for the attorney that you're working with.
Okay. All right. The only other thing we had was a comment. Just thank you for all the great information from Teresa said. You know, she said, I'll have to view your presentation again before all of this is clear. And I want to say too, you know, it is obviously a complicated world of information here, but just you've like clarified things so much to, at least from my point of view, made me understand a lot of things a little bit better, get a little handle on them. So I hope that everybody else is feeling that way too. Anybody else have any other questions?
And while you're giving folks a minute to post again, if they do, let me just mention that the handout that you received, if assuming you opened it and looked at it, is in paragraph form. It's not a copy of the slides. And one of the reasons I did that is because when you're learning brand new concepts and new terminology and so forth, for me, I don't think bullet points cut it. When you go back like a week from now or 2 weeks from now, and maybe you're actually picking this up and saying, yeah, what was it about this particular thing that I needed to remember? With a bullet point, you might be left wondering exactly what did she say? Well, it's written in sentence form, so you've got complete thoughts, and hopefully will serve you better as a reference going forward if you do want to go back and review, you know, what was it that I learned about powers of attorney that I wanted to remember? You know, what was it about those different roles of a trust? You know, what were the different kinds of trusts? So I hope it's written out so that it will help you review and retain the information that we've covered.
Yeah, and those scenarios were great. So I think, and I'm thinking back to like my own parents. Some of these prompted thoughts back to my own parents' death and the discussion about the trust and how the house was, you know, going to be, how that was all. Things have just become a little clearer to me about like what was happening back then. So, but I like your scenarios that you provided, and I think I'm gonna go home and tell my kids that they are not my heirs. But no,
Let me know how it goes.
yeah. Okay, one more. Alan says Karen is wonderful. Probably the best introductory presentation of this type I've ever seen. So,
oh, how sweet. Thank you.
Okay, so I'm not seeing any other questions at the moment. You've given so many resources too, though. We can go back to your website as well and look at the other resources that you provided. And if you'd like to watch this program again, this will be available on our Elk Grove Library website, which is www.egvpl.org. That'll be up. It just takes, I have to pass it to someone else and she has to upload it. So it just takes a few days, but it should be up there by early next week. Or if you really want to see it more quickly, you can email me actually anytime after the program tonight, and I can just send you a link for you to watch it that way too. So let me know. I'll put my email, well, you should all have my email address because you've probably gotten a bunch of emails from me, but I'll just put it there again. And this is, again, our last program with Karen for now, but we're going to have Karen back again on some other subjects. And on your website, you also list all the different topics that you cover.
I do. Yeah. So on the tab that calls, I think it's just called topics. And sure, if individuals want, take a scan through those and tell Nancy which ones sound most appealing to you, because there's a pretty wide range.
Right. Okay. Yeah. Yeah. You can go look at her website and take a look at what she offers, and or if you have another topic that you're interested in, let me know, and I will talk with Karen and see what topics we can cover in the next time we have her here. So yeah, I know some people may have joined in late, and so for sure, if you just remind me by shooting me an email at nbroten@egvpl.org, and I will send you back the link to watch this later, or again on our website later as well. But please stay in touch with me, and I'll be in touch with Karen, and we'll have her back again. So thank you everybody so much for being here tonight and taking the time. I've learned a lot. I'm sure you have learned a lot as well. And we'll look forward to having Karen back again for another topic. So I will sign off. Let's see, getting a lot of thank yous here, Karen. So thank you very much. And
My pleasure.
everybody have a good night. And we will see you again.
Okay.
Thank
Thanks,
you.
Nancy.
Okay, bye.